बड़ी ही प्यारी आवाज है, बहुत ही अच्छी काफी गाते हैं जनाब अल्लाह दिता लूने वाला।
Without quoting any judgment, without quoting, just tell us what was your first point.
My first point was that the legislative competence for the Parliament to enact the 2023 Act stems directly from a plain reading of Article 142 read with Article 191 and entries 58 and 55. That is my contention. First submission. Second, what I'm canvassing before your lordships is that the provision for right of appeal.
Before you come to right of appeal,
please go back. This is too wide. This is your contention is very general. Be precise. When you say 191, how do you relate 191? Which entry are you relating your 199 with? Are you relating it with entry number 55 or 58?
Both.
50?
Both. Entry 55 and entry 58. I'm relating it to both.
I think,
my lord,
you said that in relation to the practice and procedure bits of
yes,
the Act, you are relating it to entry 58.
Yes.
Okay, now the difficulty I'm having with that is I've told you what I think one aspect of it is, but coming now to the other aspect, you start with law under 191, you then relate it to a legislative entry which is 58. I'm just talking of practice and procedure part because and then you read it back, the principles of interpretation of legislative entries, you read them back into 191. Now, the difficulty that I'm having here is that if you look at 191 and think in terms of legislative competences, then the subject matter of that legislative competence is the practice and procedure of the Supreme Court. And on your reading of this back and forth, this has to be given the widest possible. The law enabling power has to be given the widest possible amplitude and interpretation and understanding. You will recall that the 1956 Constitution and the 1962 Constitution, both of them had specific legislative entries with regard to the Supreme Court, right? Specifically with regard to the Supreme Court. Jurisdiction, powers, this, that, and the other. Right? Now, the Government of India Act 1935, which also served as the first constitution of Pakistan up to 56, in relation to the federal court, the 7th schedule did not have any such entry, other than, the only entry was other than what is now entry 55. But there was no specific entry. The interim constitution structurally, as does the 1973 constitution, they revert the position back to Government of India Act 1935 in terms of the legislative competences, because I'm now focusing on your entry 58 argument. Now, if that argument is correct, it seems to me that that indirectly resurrects a legislative entry with regard to the, specifically with regard to the Supreme Court, which has been removed from the legislative lists, and it recreates indirectly something which the interim constitution and the 1973 constitution very firmly say, as I understand it, modeling themselves on, in this regard, on the 1935 Government of India Act, that indirectly brings in, resurrects the legislative entries that were there in 56 and 62, which to me creates this problem. Firstly, as my learned colleague some while ago said in a different context, but this is indirectly amending the Constitution. Secondly, it seems to me the very broad manner that you are talking about with relation to 58 I think that puts in doubt whether law as used in 191 is supposed to be an enabling power at all, because you are now creating a legislative competence, as you say, in the widest, broadest possible terms, which does not exist in the Constitution. What would you say to that?
My humble submission is that, and reading of Article 191 is that when it says that Supreme Court may make rules and they shall be subject to the Constitution and law, I read it that on that issue, on that subject, there is a law or can be a.
I'm sorry to interrupt you, but I'm trying to understand जिस तरह आप इसको 58 से लिंक कर रहे हैं ना, the practice and procedure parts of this act, आप जिस तरह इससे लिंक कर रहे हैं, तो then necessarily the subject, the legislative power or competence of law in 191 has to be in the broadest possible terms. But that is only possible, it seems to me, if the 73 Constitution had retained what was to be found in 56 and 62, namely specific. आप जरा पढ़ें तो सही, दीजिए साहब को 56 Constitution दें साहब को और 62 Constitution दें, इसमें वो legislative entries जो Supreme Court की हैं वो पढ़ें तो सही ना. आप तो उस चीज को रिक्रिएट कर रहे हैं इनडायरेक्टली. आप काइंडली रीड दो लेजिस्लेटिव एंट्रीज.
मलूद,
आप पढ़िए वकील साहब, पहले पढ़िए तो सही. 56 का है 5th शेड्यूल.
Is this your argument, Mr. Syed Ibrahim?
No, I'm trying to. I'll read 56 Constitution.
5th schedule. I think it's entry number 16.
Fifth, yes. Entry number?
I think maybe 16.
16. यहाँ पे.
It's in the Federal Legislative List, 5th schedule. Entry मुझे 16 बोल रहे हैं. 16. हाँ 16 है ना, एंट्री 16 देखिए, फेडरल लिस्ट एंट्री 16.
The Constitution, organization, jurisdiction and powers of the Supreme Court, including contempt of such court and the fee taken therein, persons entitled to practice before the Supreme Court.
और अब आप इसकी देखिए 62 Constitution की, वो भी चले ना रहने दें, वो more or less along the same line, just to save time. तो ये जरा काइंडली बताइए ना कि इसके अंदर जो आप जिस तरह उसका implication जो है, उसकी जो logical consequence है, does that not revive a legislative entry that perhaps consciously the interim constitution and the 73 Constitution?
Sometimes, logical consequences flow differently for different people.
I'm waiting for your answer.
My answer is that it does not, in my view. My answer is that I am reading Article 142A as being the powers, that's where the powers stem from, the power to legislate in relation to matters provided in the Federal Legislative List. The Federal Legislative List, entry 58, and if we can maybe read it perhaps.
Mr. Zahid, Ibrahim, could I just to rephrase what you were saying, and if you want to look at it this way, maybe, perhaps, that you start off with 142A, jump on to 58, and now you bounce back to 191. Yes. But this time when you come back to 191, you look at it as an entry because 58 is telling you to look at it. And all you do this time when you read 191, you're looking at the legislative competence only. And you just say there is law mentioned which could do this, and that solves the mystery.
That is what I've been trying, that is my submission.
Are you going in for the part relating to within the legislative competence of Majlis Shura
Yes.
or relate to the federation? Which part?
The first part, the first part. Fine. My
But
lord,
the first part in itself doesn't give specific direction of competence किस चीज पर है, and as was said earlier,
competition,
it says it
competence
would
in-
be anything and everything. So how do you say that from entry 58, matters which under the constitution are within the legislative competence? So then the question is, where under the constitution are you getting the competence?
191.
191.
And you're
191
reading
doesn't
subject to
provide
the
competence.
constitution?
So what is happening is, as I see it, is that you, as I said, from 142, you jump on to 58. 58 simply says, go back into the constitution and see if there is any legislative power.
Yes.
I come back to 191, but looking at 191 differently now. I just have to look at the competence, and I see that it says that there could be a law which could regulate practice and procedure. So we just have to look at the subject matter. This time round, coming back after 58, we just look at the subject matter.
That is my reading. My lord, with regard to,
Mr. Zaid, you can always say, you don't have to agree with me. We are here to hear your contentions.
and I have respectfully
You can.
said it
Are you being polite? You can say,
No, no.
don't need to agree with me.
I think it's fairly
But
clear.
Mr. Zahid, we have to
I've only
understand,
expressed.
what you are saying.
Yes, of course, and I've only
We
expressed
may
my
agree with you,
submission,
we may
of
not
course.
agree with you,
Of course,
but
and
surely a judge sitting on a bench of the court is entitled, when a submission
And I
of high
appreciate those.
constitutional importance is made,
I appreciate those
to
observations.
appreciate that.
I appreciate
And I
those
think you
observations.
appeared me enough times to know that this is the way
I appreciate those observations.
that's the way I look
चलिए,
at
आगे
things.
बढ़ें. आगे next point,
And
please.
that's the
चलें.
way how.
I'm grateful.
that's
Zaid
the way
साहब, आगे
I'm
बढ़िए,
grateful,
please.
sir. The second point that I wanting to submit is that the right of appeal is nothing but extending the jurisdiction of the Supreme Court, which is provided under entry 55. And why do I say that? First, in relation to extending the power of the Supreme Court, the argument is that this can only be done where there is express authorization. And the counter argument is, where is the express authorization? There is none, and therefore this is a redundant provision. You can't read redundancy into a constitutional provision. So express authorization, I find it in a reading of Article 10A and 2A. And there is a judgment on this that I wish to cite, my lord.
No, just a minute. Express authorization under Article
10A, right to fair trial,
and Article 2A.
objectives resolution.
No, and Article 2A.
Ji.
So is it your case, now these are, as the very appellations A indicate, that these were not there in the Constitution as originally enacted. Entry 55 has never been touched. It remains as it is. So is it your case that prior to these articles being added to the Constitution, the answer would go the other way?
My
Let's look at the Constitution on the commencing day.
sir,
If suppose on that day or the next day, Parliament had made this law with regard to the right of appeal, there was no 10A then, there was no 2A then, what would you say, what would the answer be?
my answer is, and the question I think is connected to the larger question that 185 में अपील जहाँ पे कॉन्स्टिट्यूशन ने प्रोवाइड करनी थी कॉन्स्टिट्यूएंट असेंबली ने वो कर दी अगर उन्होंने नहीं दी है 184(3) में too bad, go back, make a constitutional amendment. That is the argument, right? My contention on that is that the parliament said yes, हम 184 में अभी नहीं दे रहे, but हम ये power दे रहे हैं legislature को कि entry 55 में हम डाल रहे हैं कि you can extend your jurisdiction if at a later
The
stage.
word used is not extension. The word
Extend.
used is enlargement.
Enlarge the jurisdiction.
Now,
yes.
how do you interpret the word enlargement? As I see it, enlargement is of something which already exists. There is no appeal which exists. So how can it be enlarged?
Mr. Zaid, there could be two interpretations to that. I mean, my loud thinking that enlargement in this entry would have two sets. One is the existing jurisdiction being enlarged. The other is creating a totally new jurisdiction. Still, the Supreme Court's jurisdiction gets enlarged. So it doesn't really matter. The express provision is required for the existing provisions, but for a new jurisdiction, you don't need any.
And when you have two fair interpretations possible, which one do you go to? You go to the one
You see,
where the law will survive.
दो चीजें हैं ना, creating and in creating you are enlarging. Where is the power to create a new jurisdiction?
So that is where enlargement would come in. Most respectfully, sir.
Yeah, agar if we give enlargement a restrictive meaning, then can you give me an example when is it ever applicable then?
Sir, if I may
I mean, I can't think of a scenario, maybe you can help me think of a scenario. If we give it a restrictive meaning, the enlargement is different from creation of jurisdiction.
But
Then
also-
where will it come into play when, let's say this act did not exist and I asked you, please enlarge the Supreme Court's jurisdiction, what would you do?
It's a matter of semantics, you see. I mean, it's just a word in the sense that suppose if there is an appeal provided, would you not say that the jurisdiction of the Supreme Court stands enlarged? So it's just a word, I mean, and you've read the principles, widest possible interpretation. So
This is
you cannot be
enlargement-
lost in the word.
Enlargement of jurisdiction can be read with Article 175(2) or not, because it is a case of jurisdiction. No court has any jurisdiction unless conferred by the Constitution, by or under the law. So if you read the enlargement, is it not the appellate forum is not an enlargement of jurisdiction to the original jurisdiction of Article 184(3)?
indeed it is.
So it would be read with Article 175(2) or not, where the powers have been given.
Yes, certainly.
But the law,
My lord, what-
no, but the law over there would have to be a law that Parliament is capable of making, which brings us back to the same question.
What will go back to the same?
But you see, enlargement का तो example 185 में ही दिया हुआ है, और वो जो आपके वो थे tribal areas की enlargement, वो act का नाम ही था enlargement of jurisdiction. लेकिन आपसे तो मैं सवाल कर रहा हूँ, उसका मुझे बताइए ना, आपने अभी 10A और 2A का जिक्र किया। तो I'm giving
और
you
एक
an
चीज
example.
और है
आपने
इसमें
कहा
जाहिद
कि
साहब,
एक-
मिस्टर
एक
जाहिद,
उसके अंदर
आप सुन लें, फिर मैं आपको एक और चीज उसी के
आप
जवाब
उसके
में बता
अंदर जो
दीजिए।
है एक बात आप कर रहे हैं कि जी पार्लियामेंट के पास शुरू से ही पावर था, उन्होंने कहा जब हमारी मर्जी होगी हम लॉ बना देंगे। इज दिस योर आर्गुमेंट?
पार्लियामेंट ने उस वक्त
नहीं बनाया लॉ, ठीक है,
नहीं बनाया,
97
ये
but you say that inherent in entry 55 is the power to create an appellate right of appeal in respect to 184(3). Is this your argument?
absolutely yes.
Okay.
My lord,
Now, appeal, is it a procedural matter or is it a substantive right?
It's definitely a substantive right.
It is a
It is.
substantive.
Yes.
Council.
So you can create a substantive right by implication.
Not by implication. I'm not creating it by implication. I am saying that the injunctions of Islam mandate that you cannot deny right of appeal. And the Honorable Supreme Court of Pakistan says that this is what the injunctions of Islam say.
Which case is that? Which case is that?
Trying to get to that, PLD 1989 Supreme Court 6.
But the Honorable
Supreme Court, page 6.
Honorable Supreme Court also says that the lawmaker, if he intended to the constitution makers or framers of the constitution, if they had intended to provide an appeal, they would have done so. And if they by intention did not do so, and 185 comes after 184, then be it so. I mean, if they did not provide an appeal and now the Constituent Assembly wants to provide an appeal, let it do so. But let it be by way of a constitutional amendment.
My
and
lord,
not by
another way of looking at
by stretching entry 55 out of shape.
My lord, another way of looking at it, if we look at 184(3), वो तो इस्तेमाल ही नहीं हो रहा था, right? Later on, it started, and that is the reason that the parliament
कब इस्तेमाल होना शुरू हो गया? इस आप बताइए ना, जो इस्तेमाल नहीं हो रहा था, make your point.
I'm trying
तो चलिए आगे बढ़िए ना.
Council.
जरा आप चलते रहे ना, थोड़े आर्गुमेंट्स तो आपके हम नोट कर लें पहले. जाहिद साहब, प्लीज आर्गुमेंट्स को बताएं.
If I may, this is
Zaid Saab, as I've understood your argument,
Welcome to the full court.
entry 55 is very crucial. It gives competence to the parliament in two ways. One is enlarging the jurisdiction. The jurisdiction which already exists, its enlargement of that. And secondly is to confer supplemental powers. That is in the context of the existing jurisdiction. So, any jurisdiction that exists that can be enlarged. It is not a creation of a new jurisdiction. And it is the existing jurisdiction which is being enlarged. It is unlike Article 185, where the original jurisdiction is of the high courts of other forums. It's only the appellate jurisdiction that has been created and vested in this court. Secondly, coming back to the question, why was there a need? If as interpreted by this court till 1988, if 184.3 had been exercised the powers the way that originally were intended by the framers of the constitution makers, there wouldn't have been a problem. The problem started after 2010, when everyone was speaking about it. The voices came from the lawyers, from everywhere, that the power was being abused, and we need to acknowledge that. So now, in that historical context, merely the jurisdiction has been enlarged.
Indeed, sir. In fact,
Well, the first case that happened under 184.3 was in 1976.
but the
और
floodgates
उसके बाद-
opened later.
उसके बाद 184.3 has been exercised, yes, progressively, but then the law developed.
Yes, of course it did. So, if I may just come to page 12
That it
of
just
this judgment.
started, all of a sudden. I mean, it has been there all along in the Constitution.
Indeed.
And for the first time, the powers were exercised in 1976 and,
Floodgates opened later, sir.
yes.
Paragraph.
Mr. Zahid,
page-
please,
ये आगे
Mr.
बढ़े ना
Zahid,
थोड़ा.
जब हम पढ़ते हैं आर्टिकल 175 की क्लॉज 2, तो उससे पता चलता है कि दो किस्म की जुरिस्डिक्शन हैं
जी सर।
जो कन्फर हो रही हैं. वन इज बाय द कॉन्स्टिट्यूशन एंड सेकंड इज बाय द लॉ. तो दो किस्म की जुरिस्डिक्शन हो गई, कॉन्स्टिट्यूशनल जुरिस्डिक्शन और अकॉर्डिंगली लॉ की जुरिस्डिक्शन हो गई. अब इनलार्जमेंट अगर इन दोनों में से होनी है, अगर कॉन्स्टिट्यूशनल जुरिस्डिक्शन जो है, जो 184 से लेकर 204 तक आती है जुरिस्डिक्शन, उसकी एनलार्जमेंट अगर होनी है, वुड इट बी थ्रू एन एक्ट ऑफ पार्लियामेंट और बाय अमेंडिंग द कॉन्स्टिट्यूशन? और दूसरी, अगर स्टैट्यूट की जुरिस्डिक्शन की एक्सटेंशन होनी है, तो वो क्या उस स्टैट्यूट की अमेंडमेंट के लिए एक्सटेंशन होगी, एनलार्जमेंट होगी, या वो भी एक्ट ऑफ कॉन्स्टिट्यूशन के अमेंडमेंट के लिए होगी?
अगर
ये दोनों को मिक्सअप हो रही हैं कुछ चीजें.
सर, अगर सिर्फ कॉन्स्टिट्यूशनल अमेंडमेंट के तहत वो एनलार्जमेंट हो सकती है, तो
जुरिस्डिक्शन जो हैं वो 184, 185, 188, 186A, 188, 204 एंड 203 FE जो है शरीयत कोड की, ये जुरिस्डिक्शन कॉन्स्टिट्यूशन में है. इनकी अगर एनलार्जमेंट होनी है, कैन इट बी डन बाय एनी ऑर्डिनरी लेजिस्लेशन?
sir, because otherwise you will have to read this provision in relation to enlargement as being redundant.
नो, वो एनलार्जमेंट जो है दो तरीकों से ना, दो जुरिस्डिक्शन आ गई. अगर दोनों की एनलार्जमेंट होनी है, तो एक इंस्ट्रूमेंट है कॉन्स्टिट्यूशन, दूसरा इंस्ट्रूमेंट है एक्ट ऑफ पार्लियामेंट. तो एनलार्जमेंट करें उसी तरीके से करें, उसी तरीके से करें जिस तरीके से जुरिस्डिक्शन आ रही है.
If we say that the jurisdiction already exists, only to the extent of enlargement has the power been given to the parliament.
Enlargement, the concept of
We
enlargement
have got bogged down in
existence of some jurisdiction.
amendments to the constitution. If, suppose Parliament tomorrow enacts an amendment and says 184.3 is hereby repealed, ठीक है ना? अब तो कोई वो तो कर सकते हैं ना, हम फिर भी उसको देख सकते हैं
जी,
या नहीं देखेंगे?
नहीं, बिल्कुल
नहीं, पता नहीं क्या करेंगे. So I'm just saying कि when we concede that power, या तो कहें कि पार्लियामेंट कर ही नहीं सकती है काम, 184.3 को डिलीट भी नहीं कर सकती, because we are saying this amendment could be brought only by way of a constitutional amendment. So Parliament says, okay, thank you very much. Now I repeal 184.3 altogether, full stop. So उस पे दूसरे arguments होंगे, is it the basic structure of the Constitution 184(3) or not? But here, again, back to let's simple things. Let's see them how they are written in the Constitution.
If I may just read.
Can you just quickly finish your argument, because we have a lot of counsel to hear.
I will, page 12 of this judgment. Page 12 of this judgment.
Which judgment?
ये जो side किया
PLD 1989, Supreme Court 6.
Shariat Appellate Bench.
Shariat Appellate Bench.
12E.
12 ka, sir, the second paragraph. As far as the question that the provisions barring the right of appeal in the defense service laws are not repugnant to the injunctions of Islam is considered, we cannot agree. This court has held that the Islamic injunctions of Adl, Qist and Ahsan warrant that an aggrieved party should be entitled to test the correctness of a decision which results in the deprivation of his livelihood. See Federation of Pakistan and Others versus Public at Large, PLD 1988, Supreme Court 202, wherein the validity of certain provisions of the West Pakistan Press and Publications Ordinance, including the provisions therein which did not permit an aggrieved party the right of appeal, was considered, and it was held that the said provisions were against the injunctions of Islam and must be amended, and the right of appeal provided. The need for testing the correctness of a decision which results in the deprivation of liberty and also livelihood would obviously be greater. The court's decision in Federation of Pakistan and Others, PLD 88, Supreme Court 202, has been reaffirmed in Federation of Pakistan General Public versus General Public, decided on 17/188. It was similarly observed. And indeed, the harshness in similar provisions of West Pakistan Press Publications Ordinance was removed by the court in the same judgment. Remedial measures were ordered. The Federal Shariat Court in its impugned judgment has also held that the right of appeal was recognized by the Holy Prophet, peace be upon him, as well as the Khulafai Rashidin, and discussed this question in great detail. Nothing has been shown to us in refutation thereof. The plea thus that barring the right of appeal does not offend the injunctions of Islam cannot be accepted. So, if we read Article 2A as if it is a substantial part of the Constitution, right of appeal accordingly has to be given effect to.
Mr. Syed Ibrahim, the question here is not whether an appeal should lie or not. The question here is, if an appeal, right of appeal is not presently available and it is sought to be provided, who is competent to provide the appeal? And what mode needs to be adopted to do that? Now, one argument is that it can be provided by way of a legislative instrument, by an act of the parliament. The other argument is no, because it has its genesis in a constitutional provision. Only a constitutional amendment would provide such right. And if you would read Baz Muhammad Kakar's case, in which it was specifically said, where the Constitution or a statute does not provide a right of appeal, there is no right of appeal. And if you want to provide a right of appeal in the Constitution in exercise of constitutional powers, those have to be provided by a constitutional amendment. And if you want to provide a right of appeal in a statute, then the statute has to be amended, because this right is a creature of the statute or the Constitution. And unless the instrument which provides the appeal, or unless the law that has to provide the appeal, it is amended, it cannot be provided by implication.
Mr. Syed Ibrahim. Over here.
चले आप अपना points तो बताएं ना, हम कुछ note ही नहीं कर रहे हैं. I'm not writing anything. I'm just hearing various queries. I mean, can you complete your submissions? Please complete your submissions, and then you can respond to all the queries.
In relation to
Syed Ibrahim,
my lord.
if I may, on your reading of entry 55, would it be possible for Parliament to make a law creating an intra-court right of appeal in respect of an appeal heard by the Supreme Court under Article 185? Would that be permissible?
Your Lordship has perhaps dealt with that question, where your Lordship has even said, well, the line that, and in the end, there must be an end.
no, that's review. But I'm saying क्योंकि आप जिस तरह entry 55 को पढ़ रहे हैं ना, review का तो हमेशा ही है. And my question is, on your reading of entry 55, would it be permissible for Parliament by an act to provide for an intra-court right of appeal in respect of judgment delivered by the Supreme Court under while hearing an appeal under Article 185? Would it be possible on your reading of entry 55?
Mansoor, that would go against the finality principle because
Well,
right of
always-
appeal
Again,
against right of appeal.
इधर आप
But the logic is that here there is no
अरे
appeal.
enlarge करके भी तो देखिए ना, अगर ये section 5 जो है valid है, if it
जी.
is intra vires, petition under 184(3) is filed, whatever happens, appeal is filed, whatever happens, there is a right of review against that.
Okay, so let me answer.
देखिए जो intra-court appeal is original jurisdiction, never appellate jurisdiction. Intra-court appeal, so there'll be two streams. One is the original jurisdiction of the Supreme Court. When a special single judge of the High Court passes an order, that is original jurisdiction of the High Court. He's exercising provided under intra-court appeal. So that scenario may not be here at all because 184, 185 is already there. We are only concerned with one kind of appeal, which is 184(3) appeal, nothing more.
No, I think
I understand your lordship's question and let me answer it.
आप जितना broadly entry number 55 को पढ़ रहे हैं तो उसकी implications है ना.
जी.
अगर उसकी implications fail कर जाती हैं तो that's one thing, उसकी implications alive रहती हैं, that तो इसलिए समझने की बात है ना. या तो आपका केस है कि जी appellate jurisdiction में नहीं हो सकता, further ये power खत्म हो गया, मुझे तो फिर नजर नहीं आता उसमें कोई ऐसी limit.
नहीं, मैं ये नहीं कह रहा, मैं वाज़ेह तौर पे ये कह रहा हूँ कि जहाँ तक power of enlargement है, that exists not just in relation to 184(3), it exists. And my answer is, the line that in the end, there must be an end, unless the parliament says so. Unless the parliament says so. That is my...
You added words to my words.
Yes, indeed. I'm taking the liberty of adding the words, unless the parliament says so.
I may or may not agree with you.
Subject to your... Grateful, sir. Sir, if I may move to the next point. This challenge has been dressed up as an issue of independence of judiciary. There is a plethora of case law which identifies that how important, crucial, critical independence of judiciary is to our system. In relation to what constitutes independence of judiciary, what are the things that make up independence of judiciary? My Lord, I will not make your lordships read, but I'll just cite the relevant paragraphs of a few judgments. My Lord, the first is the Afridi case, PLD 1994, Supreme Court 105, at page 107.
Please repeat the citation.
My Lord, PLD 1994, Supreme Court 105,
At?
107.
Okay.
The second is PLD 2009, Supreme Court 879, the Sindh High Court Bar Association case, at page 1228, para 17. And lastly, PLD 2010, Supreme Court 61,
2010 Supreme Court?
page 61. This is my Lord Chief Justice 𝐃𝐚𝐰𝐧𝐍𝐞𝐰𝐬 versus President of Pakistan. And the relevant page is 173, para 157. My Lord, in relation to international treaties and covenants, which also define what independence of judiciary is, I have taken the liberty in my concise statement in paragraph 10. I have drawn out what these international treaties say. I will just read one sentence from there, my Lord. Independence of judiciary, according to the Council of Europe recommendations, says, The principle of independence of judiciary means independence of each individual judge should be able to act without any restriction, improper influence, pressure, threat, or interference, direct or indirect, from any authority, including authorities internal to the judiciary. This is the first definition of independence of judiciary that I was able to gather, which specifically says that from internally from the institution, there has to be independence. My Lord, repeated questions have been raised, but no one has identified which fundamental right affects the petitioners. How independence of judiciary is diluted by this law. An argument is certainly made that once we open this door and allow the Parliament to legislate in relation to even the practice and procedure of the Supreme Court, tomorrow the Parliament may make another law. My Lord, when it makes another law, it will be tested whether they are interfering in the independence of judiciary. And it will be struck down if they do so, but not at present. This law does not. My Lord, most humbly, under Article 184.3...
Ibrahim, how do you say that? Where the Act obligates the Chief Justice or the two other judges to act in a certain manner, and as was rightly pointed out by one of the counsels, they are micromanaging or trying to micromanage or trying to interfere in the independence of the judiciary insofar as the Parliament will now dictate how benches are to be formed or how what cases are to be fixed by the committee or by the Chief Justice, and what would be the number of judges sitting on the benches, and how would the roster be made, and what sort of cases which go before what sort of benches. I mean, if this is not interference in the independence of the judiciary and micromanagement of the judiciary, I don't know what else would be.
My Lord,
I think this is premised. I think we should also realize that this was premised on undermining the office of the Chief Justice. Now, if the office of the Chief Justice, at least I do not read it as the same as the judiciary. I think judiciary means everyone. Chief Justice is a person. So yes, it is premised, but when I use the term independence of judiciary by saying Chief Justice, then we should use the word independence of the Chief Justice and not use the word judiciary. And then the argument goes back and forth, the same one, he is the head of the institution, so he represents the judiciary. I'm not very convinced with it. So I would say, yes, it definitely undermines the independence, or whatever better word you want to say. Use not the word independence, but some other word may be better, of the Chief Justice, but not as a judiciary as a whole.
Two very brief responses. Your Lordship should give credit when this law was being debated in Parliament. The very point that your Lordship has said was also raised. And they said...
in fact, incidentally, there are two orders of this court, and the learned Attorney General also undertook to place on record the debates,
in an earlier hearing, it was pointed out that it is available online.
If that order
I think it's been placed by
with,
one of the lawyers. It's available in CMA 8565. One
I
day's
think
debate
it's
has
a
been
good
placed.
150 pages.
Some parts of it have been placed on the file.
All I was trying to point out that the questions that your Lordship has raised, the Parliament also grappled with it. And in my humble view, these matters can't be looked in an isolation. Let's face it, I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April, and on the 13th of April it gets fixed.
So, Mr. Zaid Ibrahim,
This itself is a vindication of this law.
can be fixed by the Supreme Court itself.
So,
If you point
all
it
the
out
Parliament
to the
is
Supreme
saying,
Court
all the-
and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues.
Sir,
How does the Parliament come in?
Order
then I
19
can
of the Supreme Court rules, Order 19 of the Supreme Court rules says that all appeals filed in the registry shall, as far as possible, be heard in the order in which they are set down.
Okay. So
Does it
it's a
happen?
question of
I mean-
implementation. So according to you, the rules are already there, they are not implemented.
No, so-
if it is incorporated in a statute, it would ensure implementation.
It
Mr.
is not
Zaid Ibrahim-
incorporated in the
Mr. Zaid
statute.
Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen us, which would strengthen the Supreme Court, enhance the independence of judiciary. I'm okay with that coming in the door. But if something else walks in the door which affects my jurisdiction, reduces my jurisdiction, violates fundamental rights, access to justice, independence, I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red herring.
And again, Mr.
Zaid
Zaid Ibrahim,
the main question is,
Mr. Zaid
the main
Ibrahim,
question
all
here
that,
is
all
whether there
that
is
the
a
Parliament
door.
has done.
Yeah, door is the question that will determine.
The Constitution, for the
Zaid-
time being,
Zaid Ibrahim.
does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether it all is a door or not.
Mr.
What comes
Zaid
through the door
Ibrahim,
is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has stated. I view it differently. The Parliament, since this court having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is try to structure the discretion, which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the Constitution, in light of this law, who is the master of the roster?
Well, according to one judgment,
No, I'm talking of the law. In light of this law, who is the master of the
I'm
roster?
not sure where the term even master of roster comes from.
Who decides which cases get fixed where, etc.,
The
etc.?
committee decides. The committee.
No, you're wrong. Committee is the creature and creation of Parliament. At its broadest level, this law is a claim by Parliament that Parliament is the master of the roster. And I'm asking you a question. You don't have to, as already pointed out by the Honorable Chief Justice, you don't have to agree with the question. To me, this is the crucial aspect of this law. It is not whether the committee consists of 3 judges or 5 judges, or Parliament says, let the full court do it, or let the Chief Justice do it. Those variations, as has been pointed out, you said it, maybe that those laws will be made, maybe they won't be made, that's speculative. Whether it is speculative or not, I put that to one side. The point is, and this is the question I'm putting to you,
Yes, ma'am.
that in any of those scenarios, including the one that we have before us today, it is not the committee that is the master of the roster, because the committee is a creature of Parliament's will. Parliament has willed it into existence. Therefore, It is Parliament that is the master of the roster. Now, placed at that level, it seems to me that this is directly in conflict, directly contrary to the principle of independence of judiciary. What would you say to that?
Can the master
I
of the
would
roster,
say- I would
Mr. Ibrahim, can the master of the roster speak? I would add the word the purported master of the roster. When I became Chief Justice, and I looked at it earlier also, the existing rules of the Supreme Court of 1980 stipulate simply that the Chief Justice will constitute benches. Now, practice had developed, maybe it's in accordance with the rules, I can't find it, that every week, list of cases prepared, a list would go to the Chief Justice, this case would go to that judge, and this case would go to that judge, and this case would go to that judge. I have discontinued that practice. This is not even the job of the Chief Justice. This is the job of the registrar. They can be given broad outlines, first in, first out being the general principle. Then there can be fast-track cases, election matters, naturally election matter will become redundant after a certain period of time, bail matters, etc. But to see even the cause list of the day and where it goes, I think, and this is the master of the roster speaking, please give me this power so I can use it from the existing Supreme Court rules. Where do I have this power? I can't seem to find it. Can you help me with that?
And Mr. Zaid Ibrahim, there are no masters anymore in the world, you see. If you look around...
He always wants to undermine my authority.
With respect to the
lighter
master.
note.
So I don't see that as a master. So Mr. Zaid Ibrahim, what I want to say is that if you look at internationally, it's about time we wake up to the world, you see. We have US, UK, Germany, Brazil, Nepal, Philippines, just to name a few. There's no such thing as master of the roster. It's a collegial system that works, and that's across the board. And it's about time that we also woke up to all this, you see.
My lord,
With due respect to the master here.
Utmost respect, I say we need to wake up to what's outside this room.
You see if I may add to that,
And to answer...
under our system, and I don't mean to be disrespectful to anyone, masters come and masters go.
Yes.
This is not a lifetime appointment.
But while they are there...
No, just a minute. One Chief Justice may have one view of the matter, the other may have another view. And those who come, and I don't mean immediately, I'm not talking of potential Chief Justices sitting here, I'm talking even way into the future, they will do whatever they want to do. But that is not the important point. The ephemeral, fleeting, whether it's 1 year, 2 year, 3 year term of a Chief Justice, of a master, if you want to put it that way, in the more traditional sense, that is, in a sense, beside the point. The question is, within the framework of the Constitution, separation of powers, independence of judiciary, ultimately, who is the master of the roster? And can Parliament lay such a claim and not violate the Constitution? This is the ultimate question.
But if I could just bring in another dimension to this, I don't know if you've looked at this new book called The Court on Trial, and they've done a data-based analysis of the Indian Supreme Court, where they say that invariably through data they've discovered that Chief Justice, if he has all the powers, he can manipulate cases. He can ensure a certain outcome. This is through data that they've presented. They've said that judges who have been dissenting, Subha Rao is one of the judges who dissented several times during his tenure as a judge, but as a Chief Justice, he never dissented because they would manage the bench. So this has been through data now established that if one person could get a bench constituted, get the judges on that bench, he could ensure the outcome. Don't you think that sort of directly hits at the core of independence of judiciary?
Of course it does.
And again, Mr. Zaid Ibrahim,
I've also read the book that my learned colleague is talking about, and I look forward to having a very enjoyable discussion about it with him. But the thing is, if the principle, it's the principle that matters. If one man can do it, maybe 3 persons can do it.
Your Lordship,
maybe 5 persons can do it. No, if you don't like following logic to wherever it goes, then the logical answer is everything should go to the full court, but that's practically not possible.
Mr. Zaid
The
Ibrahim.
point is, the principle of the thing still stands. My question to you still stands.
I
Yes.
want to have
Please
the
answer
opportunity
that.
to answer it.
Respond करें उसमें.
The answer is in two. First, I would urge your lordships to not read this law as an encroachment into the independence of the judiciary. By no stretch of imagination is this. Even in Parliament, when this was discussed, it was discussed that the bar has wanted to do this for a long time. But PTI is challenging their legal counsel. Hamid Khan was cited in the debate as supporting this law. To answer your question, Parliament does not seek to be the master of roster of any.
Not a question of whether they seek to be this
Or they have
seek
not.
this.
Mr. Zaid Ibrahim.
The principle that is being established is that they are. Whether they seek it or not is beside the point.
Mr.
This is
Mr.
the
Zaid
core
Ibrahim.
of the question.
I would
Mr.
say that it is
Ibrahim,
not.
In
And
most
secondly,
of,
secondly,
Mr.
in
Zaid
relation,
Ibrahim,
Just on the
Sir,
lighter
एक
in
second,
note,
most of the jurisdictions,
the only
the
way I
fixation
cannot
of
read
cases-
into this is to keep my eyes closed.
no, is to not chase
Mr.
shadows.
Mr.
I would say
Zaid
not chase
Ibrahim.
shadows. And just one last thing. My lord, your lordship had said that, oh, chief justices are there for 1 year, 2 years, they go, new chief justices come, and it's not you're stuck for this forever. But my lord, what do we tell people who had
No,
homes in Nasrat
know,
Tower?
I think, no,
What do
sorry,
we tell
Mr.
people
Zaid,
who lost
Mr.
jobs,
Zaid
employment,
Ibrahim,
lives, property?
Mr. Zaid
There
Ibrahim,
should be a right of appeal.
ये देखिए, let this message not go out from this court that the constitution and the laws of Pakistan are dependent on who the Chief Justice of Pakistan is. This message must not go out from this court. The laws of the constitution and the laws of Pakistan are there, irrespective of the size of the Chief Justice's foot. So let this message not go out that the next Chief Justice can do as he pleases. Absolutely not. Let that be clear that what the law is, what the constitution is not a variable commodity subject to the whims and wishes of the Chief Justice of Pakistan. That must not be so. And if that is so, that is destructive of the constitution. It is destructive of the rule of law. It is destructive of the independence of the judiciary. It is destructive of everything. If we go that far and say, oh, let the next one come, he'll retire, 25th October, he goes, the next one will come, he'll do his own way. No, absolutely not. He should follow whatever is the proper method of doing things. It's not, I mean, sorry to say, if anybody thinks in that side, Parliament, or in any other situation that he becomes all powerful, I at least will not let this institution put forward this thing, we will do as we please, when we do. Here we have autocrats writing books, friends not masters. We don't want to even say that. I am not anyone's master. I am servant to the constitution and an abd of the Almighty. That is the place of a judge. It should remain there. It should not be variable commodity. Oh, the next justice, how will he do it? So I don't. This is a very unhealthy sign. If it is so variable, then where the Supreme Court's change laws. I mean, a law is enacted today. The way it goes up, interpreted by one court, by the other court, by the higher court, by the time it comes to the Supreme Court, takes about 20 years for any law to settle. Now, if it's such a variable commodity that we sort of stump everything and we come 184.3, today the law of Pakistan is this.
Certainly, we look for consistency,
Mr.
and that's
Zaid
what the
Ibrahim,
legal
I
system
think,
should provide. Yeah,
if I'm not wrong, in most of the jurisdictions, they have adopted objective criteria for fixation of cases and constitution of benches. And they have named it as the natural judge concept. And they have done away with the concept of master of the roster. It's done on an objective basis, laid down criteria, and not on the basis of a discretion vested in one person.
I think it's high time that we bury masters and bring in trustees.
Yes.
In fact, the Constitution starts with that word. It's a sacred trust. Because you have mentioned Islam, but I was surprised nobody else is mentioning Islam. I mean, It's
I've
mentioned
mentioned
on
it
the
to the
streets
extent that
more
it
than
was
it is in the
relevant.
courts of law.
Most grateful, sir. Thank you for the opportunity.
Mr. Zaid,
Yes, sorry.
बड़ी इनके जो जितने भी मास्टर ऑफ रोस्टर्स प्रेजेंट और फ्यूचर के होंगे इनसे माजरत के साथ ये देखना है कि इस लॉ में आया ये बताया गया है कि कितने बेंचेस किस तरह बनेंगे या कौन बनाएगा
सर
किस तरह बनने में और कौन बनाएगा में जरा फर्क होगा
वो आप लोग आपके ऊपर छोड़ा हुआ है जिस तरह आपने कहा कि जो आगे आने वाले लोग हैं और जो हैं उन्होंने आप लोगों के ऊपर है ये पार्लियामेंट वहां पे नहीं फैसला होना है आप नहीं करना है ग्रेटफुल मतलब मोस्ट ग्रेटफुल थैंक यू
Who do you represent?
Lord, I represent the PMLN. My concise statement is 8301 of 2023. My Lord, I'm sorry I have committed the same mistake as some of the earlier councils. जो extracts or foreign judgments थे मैंने अभी दिए हैं.
8301.
I apologize, sir.
अब president बन गया है.
Sir, I'll keep a mind of it. In future, sir, I'll be careful of it.
8301 अगर निकाल लें.
May I?
G.
Lord, first of all, there's a question of maintainability. At least as far as I am concerned, sir, I'll not be raising that issue. And for the reason that the last time I was on my legs before an 8-member bench, my argument was that due to the public importance and constitutional import of this case, it should be heard by a full court. And,
आगे बढ़ें.
sir, now on merit, sir, there are 3 questions to my mind. Firstly, can Parliament legislate regarding practice and procedure of Supreme Court and in any case override provisions of the Supreme Court rules 1980? Number 2, can Parliament create a right of intra-court appeal against orders under 184(3)? And number 3, whether even assuming the above can be done, do the provisions of the 2023 Act otherwise somehow conflict with any provision of the Constitution? Now, before taking your lordships to the relevant entries and Article 191 and so on and so forth, I'd like to make some submissions, sir, regarding the overall conceptual framework within which I view this issue, and also the background and necessity of the legislation, especially since the petitioners and the counsel for the PTI have directly attributed a malafide political intent behind this act, arising from a desire to subjugate the independence of the judiciary. Now, I agree with the petitioners that issues relating to independence of judiciary do directly engage fundamental rights guaranteed under 9, 10, 10A of the Constitution. But there is a crucial difference between all the previous cases decided by this court, Meram Ali, Rawalpindi District Bar, Liaquat Hussain, Al-Jihad, etc., and this particular case. All the previous judgments of this court basically deal with external threats to the independence of judiciary. My humble submission is that this case primarily relates to internal threats to the independence of judiciary. It is what Justice Asif Saeed Khosa, as his lordship then was, referred to as the final frontier of judicial independence. My submission will be that the constitutional guarantee of independence of judiciary covers both external independence and internal independence. Now, I'd like to start, sir, by reading two short passages from the article of Justice Khosa. He wrote this when he was a judge of the Lahore High Court. So this is page 1 of the booklet. And if your lordship will see page 4, I'll read a couple of passages from there, and page 6. So the second para, page 4. Now I come to the fourth stage, which I call the final frontier. In my capacity as a lawyer, I had written and spoken about independence of judiciary on several occasions, but now my perspective and angle are slightly different. Having spent a good number of years on the bench, I have seen the system from within, and thus I know and understand a few things which an outsider may not be in position to appreciate. In this background, I intend to share some aspects of independence of judiciary which are generally overlooked. But these aspects are so important that without attending to them, the whole superstructure of independence of judiciary remains incomplete, and if I may say so, shallow and superficial. I'll skip a para, sir, to save time, then the para after that. It is some of these areas and aspects, often ignored and overlooked, which I intend to highlight. The earlier stages I have mentioned are essentially relevant to threats to independence of judiciary from outside the judiciary. But the final frontier envisioned by me is the stage where independence of judiciary is achieved through a successful passage of the earlier stages, is to be protected from the threats originating from within the judiciary itself. Three areas appear to me of particular importance in this context: independence from oneself, independence from judiciary, and independence from justice. Now, if your lordship will turn the page to page 6. In the first part of the final frontier, he deals with how judges have to rise above their own personal inclinations, ideological inclinations, biases, so forth. And then the second part is discussed here. The second aspect of the final frontier is the independence of an individual judge from the undue pressures of his peers and from unnecessary or unwarranted controls of his institution. There is no doubt that in his capacity as a judge, a person performing judicial functions is necessarily a part of his institution, i.e. the judiciary, and ordinarily his functioning is to be in line with the overall policy and scheme of the institution. However, the problem comes when the institution's independence is itself under cloud because of extraneous factors, and an individual judge starts abdicating his decision-making before the dictates of the institution, or conversely, when the institution starts excluding an individual judge from decision-making in sensitive matters because that judge is not likely to toe the line of the institution. Both these factors, which may be unthinkable in the civilized world, are unfortunately real possibilities in some other parts of the world and completely undermine the notions of independence of judiciary. Apart from the above, concentration of powers in the hands of the head of a judicial institution regarding constitution of benches, allocation and distribution of cases amongst benches, attaching priority to different kinds of cases, and geographic transfer of judges is an issue which has raised eyebrows in the past and can also resurface in the future. A possible misuse of such powers by the head of a judicial institution can effectively render the independence of an individual judge to be of no practical utility or benefits to the citizens at large. Such a threat to independence of judiciary has its origins within the judiciary itself, and any degree of independence of judiciary painstakingly achieved through all the other stages mentioned above can effectively be neutralized through machinations from within the judiciary itself. In this context, I feel that independence from judiciary in the above mentioned areas may be a sine qua non for reaching the final frontier of independence of judiciary. Now, of course, the author of this article eventually adorned the office of the Chief Justice of Pakistan. But nonetheless, for whatsoever reasons, no structural change could be brought about to achieve this final frontier of judicial independence. Now, this concern about the untrammeled powers, the untrammeled discretion of Chief Justices is not unique to Justice Khosa. Another future Chief Justice has also...
Mr. Salahuddin, it is a person-specific argument which you are raising before us.
Not at all, sir. What I am saying is that this argument, this concern has been raised by multiple of your lordships.
The issue before us, to come to that.
Yes. The issue that I am coming to, sir, is that there have been multiple concerns expressed by the judiciary itself about the concentration of powers in the office of the Chief Justice and the potential for abuse of those powers and the perception that it creates in the general public. Now, those are exactly the issues when Parliament is being accused of acting with...
The matter relates to the institution.
Yes, sir.
Please, we are sitting to hear you.
Let's go for let's look at the law. Your point is taken. You feel that there are voices coming from the bench. Fine, point taken.
Mr. Salahuddin, whatever you are saying assumes competence. That's the key points over there.
I will come to
all
both
of this
those.
may be right, all of this may be wrong, some of it may be right, some of it may be wrong. Tell us about competence.
I will address the issue of competence if your lordships will allow me.
ये तो किसी का अपना view है होगा.
Sir, bilkul. I will cite, I will just cite, not read from them, but I will cite the different judgments in which at least I think, if I'm counting correctly, 10 members of this present bench have raised concerns about the concentration of powers in the office of the Chief Justice. And my submission would be that that in itself dispels any argument of malafide.
Does that in itself confer legislative
No, sir, it
competence
does
on
not. It
Parliament?
does not, and I will deal with those independently. I'm just completing this, sir.
Kindly tell us what you say about who is Parliament the master of the roster?
Yes.
As a matter of principle.
If you're, I will come to that, sir. I will come to that.
किसी की कोई view है, किसी की क्या view है?
Yes, I will come to that. I just want to quickly cite those judgments, sir. PLD 2019, Supreme Court, page 183.
183.
Yes, sir. PLD 2021.
What proposition is this?
Sir, these are all judgments and dissenting notes and additional notes in which different judges of this court have on various occasions raised.
I think you should be a bit careful. With all due respect, I don't want to stop you from making your submissions, but you're treading on relatively thin ice here, in the sense that if you're quoting a retired judge, that's one thing. But if you're quoting sitting judges in this particular context, before a full court, when the very competency of Parliament is under challenge, I think it's better for you to just focus on. I hope you understood what I'm saying. I don't want to say anything
I'm
further.
not, and that's why I'm just placing
Please don't.
I would like to hear what you're saying. I would like to hear what you're saying.
judgments before your lordships. I'm not
Citation
any
बताइए.
extraneous material.
Please cite them.
Citation बताइए,
Sir,
citation.
PLD 2019, Supreme Court 183. Then PLD 2021, Supreme Court 446. There is a dissenting note in that.
कोई relevant pages आप नहीं बता रहे हमें. Relevant pages.
Sir, I'll dig them out then, sir. PLD 2021, Supreme Court 446 में, sir, it is.
इसका टाइटल केस का क्या है?
Sir, ये PM's discretionary fund है. The earlier one is.
चलो लिख के दे देंगे pages.
जी मैं दे देता हूँ,
आप
sir.
citation
जी,
से.
मैं दे देता हूँ, sir. Then there is PLD 2023, Supreme Court, page 306. There is PLD 2022, Supreme Court, page 3006.
2023 Supreme Court.
PLD 2022, Supreme Court 306.
23 का भी आपने बताया, ये 22
so
का भी same page.
जी, नहीं, PLD 2023, Supreme Court 306 and PLD 2022, Supreme Court 306.
Both have the same page.
And उसमें this second one, sir, जो 2022 का है, that is suo motu case number 4 of 2021. And in that,
देख लेंगे ना, let's just
I rely on paras 53 and 56.
53.
Which citations is there?
That's it.
And sir, there is SMC number 1 of 2023. There are 3 separate notes in that.
Reported or not reported?
Sir, not reported as yet.
SMC number?
1 of 2023.
ठीक.
And SMC number 4 of 2022. Now, in addition to that, sir, the bar councils and bar associations have obviously been passing resolutions on this issue for almost a decade.
Again, to the bars
Yes.
council.
question.
What does that have to do with
My lord,
competence?
there is.
I mean, are we supposed to be swayed by, with all due respect to what, those are extra judicial
Not at all.
statements?
Not at all.
Kindly
Your
talk the
lordship-
language of the law.
Your lordship will appreciate.
See,
That's-
कानून की बात कीजिए, ये तो नहीं कि
Salahuddin, there are only 2 questions involved here.
Ji, sir.
One is who is competent, question of competency. And 2, if we come to the conclusion that yes, there is competence, then you have to convince us that the law as framed is not in conflict with any provision of the Constitution. If you would kindly address these questions, I mean, most of your case would be
My lord, what
encompassed in that.
I'm grateful to your lordships. What the main challenge by the petitioners has been on 2 grounds. One, that it infringes, the legislation infringes the independence of judiciary. That is one completely separate issue. And the second is that it is beyond the legislative competence of Parliament. Now, in the legislative competence issue, obviously, whether the law is an excellent law or a terrible law is irrelevant. I will gratefully adopt your lordship's formulation on that. But as far as the challenge on the basis of independence of judiciary is concerned, the merits and substance of the law and its background is very relevant. That is why I'm briefly, I'll come to the legislative competence too. Sir, if your lordships will see that I'm not going to go through the resolutions or anything, but they are at page 171 to 185 of that booklet.
But
And if your lordship,
one thing, I've seen judgments of this court which have cited news reports for relying on various things, and consequences have flowed from those news reports. So I, for one, do respect what the highest bodies of lawyers have to say, whether it be the Pakistan Bar Council or the Supreme Court Bar Association, most ably represented by Mr. Abid Zubairi. So if you want to file those, I mean, I would place greater credence on them than on newspaper reports which have been taken note of and judgments passed by relying thereon. So if we keep talking about this chariot perpetually ad nauseum, the 2 wheels of the chariot, now let us see this chariot work.
it is, in my humble submission, is that they are relevant.
I think competence of a law is never been, as far as I
I certainly want to hear a person's point of view.
is decided on the basis of newspaper reports. Those are other contexts.
Yes, legislative competence is a separate issue. I'm dealing right now with the independence of
Right now
the
you-
seeming
No,
infringement.
but independence of the judiciary itself is, if it is violated, then the law is incompetent. Competence is not just legislative competence. Competence is also competence vis-a-vis other provisions of the Constitution.
My lord,
And what the people perceive independence to be, and more so than the people those dealing with the law, which is the legal community. So I definitely want to see the perception of independence. I mean, it may be very independent, but people may think it otherwise, and vice versa. It may not be independent, and people may think it very independent. So yes, you don't have to spend a lot of time on it. If you can just refer to them or give it to us.
They are at pages 171 to 185. And they are resolutions that I have been, what I was able to discover were only dating back till 2018, but I understand PBC has filed something going back to 10 years ago. But there is just one aspect of those resolutions that I would ask your lordships to consider. If your, and that goes to some of the questions that have been raised. If your lordship sees that initially in all those resolutions, the request was for this court to amend the Supreme Court rules to regulate the suo motu power and to regulate the master of roster power. That was the demand for the major period. Eventually, there has been a change in the tone and direction in the last 2 or 3 years, which has then now, in the more recent resolutions, asked for Parliament itself to directly act under 175 and 191. And presumably, the change in direction was because there was no effective response from this court on its administrative side. I'll move on, sir. Now, Justice Hilali had asked 2 pertinent questions, and Mr. Zahid Ibrahim had also pointed out the need to look outside. And those 2 questions was, one, if the CJ's power to form benches and assign cases was taken away, what would be left of the CJ's office? And secondly, how the formation of benches and fixation of cases is dealt with in other countries. Now, the answer to that first question is that there are certain specific powers and rights of the Chief Justice that are enshrined in the Constitution itself. There are about 9 that I can think of. I'm not going to go through them all, but they are there in my concise statement. Apart from the ceremonial powers, there are 9 concrete powers. The power to make benches and assign cases is not a constitutional power at all. It is not mentioned anywhere in the Constitution. In 1935, in the Government of India Act, it was indeed a constitutional power of the Chief Justice. In the 1956 power, there was a direct provision in the 1935 Act. In 1956, that power was moved to the 3rd schedule of the 56th Constitution and made subject to rules, and then by virtue of Article 177 made subject to Act of Parliament.
This was
After
1962?
1956.
56.
3rd schedule में थी power that the Chief Justice may subject to rules, form benches, etc. And that was in turn subject to Article 177.
What about the power under the Government of India Act 1935, which was the first constitution of Pakistan from 1947 through to 1956? What was the, how was the power there framed?
In the 1935? I'll just read the exact.
What is the section?
Ji, sir.
Read section 214.
It is 2143. Subject to the provisions of any rules of court, the Chief Justice of India shall determine what judges are to constitute any division of the court
Kindly read subsection.
and what judges are to sit for any purpose.
Power of the roster.
Ji, sir?
The power of the roster.
Yes, it was there.
Now, actually, the power of the roster goes much further back in time. Have you seen the Indian High Courts Act of 1861?
No, sir.
Let me tell you where this power comes from and how it ends up in the judicial case law. You see, after the British took direct rule of India in 1858, one of the first laws that was made in 1861 was in relation to the power to issue letters patent to create high courts. Madras, Calcutta, Bombay and all that. So this is something that goes back to the very beginning of British rule in India. Now this provision, this Act of 1861, also had something to say in relation to that. Let me read out to you section 14 of this Act, 1861. Because at that time there were only high courts, right? Federal court comes in 1935. The Chief Justice of each court shall from time to time determine what judge in each case shall sit alone and what judges of the court, whether with or without the Chief Justice, shall constitute the several division courts as aforesaid. So the Chief Justice as the master of the roster is a power that goes back to the very beginning of British rule and whatever follows thereafter. This position continues for several decades until we reach 1935. In between, we have the Government of India Act 1915. वो आपने देखा है? नहीं. उसमें भी section 108 था, which was in exactly these terms. ठीक है? अब आपका आ गया 1935 का Government of India Act, where you just read out for us subsection 3, right? Subject to rules made. But the rule-making power under subsection 1, legislature had no interference with that.
Yes, sir.
Then we have the
But the Governor General did. It was with the approval of the Governor.
Approval. He couldn't make them, he could only approve.
Yes, but the approval in his discretion.
As originally contained.
My lord.
Now we come to the 56th Constitution, uske provisions aapne hame bataye hain. Then we come to the 1962 Constitution, where the article takes the shape that it now has. But the 62 Constitution, as I said when Mr. Ibrahim was arguing, in the third schedule, it had a specific legislative entry for Supreme Court.
Yes.
Interim Constitution reverts structurally to the position of
Government in India.
1973 Constitution does that. Now it seems to me that if you look at the grand sweep of constitutional history, starting from 1861 onwards, the 56th Constitution, which is perhaps the high water mark of legislative interference with matters related to the power of the roster, out of those centuries-long period, this is a very narrow window, hardly a few years, right? This expanse, which I think is about 150, 160 years, then culminates in the judicial case law, the case law that was referred to by Mr. Bindari, that it is the Chief Justice who is the master of the roster. Now, this is not something that the judges were creating out of thin air. This was a rule going back centuries old. It was deeply etched in the law. Now, the question to you is this. Mr. Bindari said that there is a constitutional convention that the Chief Justice is the master of the roster. If you look at the expanse of constitutional history, if you look at it in historical perspective, it is at least arguable that there is this convention, or at least a constitutional rule of ancient standing, right? The question to you is this. In our constitutional law, conventions are legally enforceable. So even if this rule is only now embedded in case law, can it not be said that it is a constitutional convention, and therefore sections 3 and 4, setting up the committee and so on, they are ultra vires, even though it's not there in the express text of the Constitution. But conventions, by definition, have to look at the much broader perspective of constitutional history, right? Looking at it from that perspective, perhaps at least it's arguable. I'm not saying it's at least arguable that what Mr. Bindari was saying was correct, that there is a constitutional convention, and therefore it's beyond what Parliament has done or sought to do in sections 3 and 4. What would you say to that?
My lord, respectfully, I take a completely converse view of the constitutional history. To me, it seems that under and prior to the 1935 Government of India Act, but under the Government of India Act, there's an express provision in the Constitution itself regarding the role of the Chief Justice. In the 1956 Constitution, that is diluted somewhat, that power is taken away to a schedule, schedule is made subject to rules, rules are made subject to the Act. 62 onwards, the very mention of the Chief Justice's power as master of the roster is removed from the Constitution. So to me, it speaks of a constitutional intent to reduce the role of the Chief Justice and enhance the role of the Honorable Supreme Court.
But Mr. Salahuddin, the point is it is removed from constitutional text. But the question I'm putting to you is the submission made by Mr. Binjari that it is a constitutional convention. Conventions by definition are not in the text. And if it is a constitutional convention, which is recognized in that Hamid Sarfaraz case, PLD 1979 Supreme Court and other case law, that constitutional convention does not emerge suddenly out of nowhere. That constitutional convention has the backing of centuries old constitutional practices and even matters which are textually to be found in the relevant statutes. If there is this convention, and conventions are recognized under our constitutional law, would that not be in your sections not be in violation of
My Lord, my understanding, I'll just give a brief answer and then move on. My understanding is that constitutional conventions are subordinate to actual constitutional intent as expressed by words. Now, if the legislators remove a particular constitutional power, one cannot just disregard that removal. That removal must have a purpose. And my submission is that the purpose of the omission of the Master of Rolls power from the Constitution is to empower the court in favor of the Chief Justice. I'll move on, sir. Now, well, the second question of your ladyship was...
Mr. Salahuddin, Chief Justice is holding a constitutional post.
Yes.
And the powers exercised by him are not constitutional.
My Lord, there are some powers that are constitutional, 9 in fact, which are mentioned in Article 10(4), 146, 152, 159.
Where it is differentiated that he cannot exercise the constitutional authority.
My Lord, because the power as master of roster comes to him by virtue of the Supreme Court rules. It does not say in the Constitution.
In present circumstances, those powers are exercised in pursuance of Article 191 of the Constitution.
No, sir. Yes, indirectly. Yes, from 191 and then the Supreme Court rules and then.
Those are framed under Article 191.
ये जो present scheme of Constitution है ना, you just explain the legislative competence on the present Constitution.
जी.
क्या आपका इसके अंदर है?
Sir, I'll just come to sir. एक मैं quickly complete कर दूं, sir. Because there was a question about what is happening elsewhere, and I think that will inform the reading of our Constitution as well. Sir, एक इंडिया का मिसाल दिया था भंडारी साहब ने शांति भूषण की judgment cite की थी, where the Indian Supreme Court has held that the Chief Justice has absolute prerogative as master of the roster. But the background of that judgment, and I think this is perhaps the article here that your Lordship had referred to, that is at page 10 of the booklet. And the background is very instructive, sir. What happened was that in January 2018, 4 senior-most judges of the Supreme Court of India held a press conference against their own Chief Justice. And they said that cases having far-reaching consequences for the nation and the institutions have been assigned by the Chief Justice of this court selectively to benches of his own preference. Now, just a month before this press conference, there was a case which is reported at 2018 1 SCC 196. It's page 124 of the booklet. in which the powers of the Chief Justice, the case fixation powers of the Chief Justice were challenged. The Honorable Chief Justice of India formed a bench, presided over it, and dismissed that petition. Then after the press conference in April 2018, Chief Justice Deepak Mishra again headed a 3-member bench which heard Ashok Pandey's case against the Master of Rolls powers and seeking an amendment to the Supreme Court rules, and he dismissed the same. That is at page 128 of the booklet. And only thereafter, in July 2018, Shanti Bhushan's case was decided following the earlier 2 precedents. Now, interestingly, in India, one of the Chief Justices who held the press conference, one of the judges who held the press conference against the Chief Justice, Justice Raman Gogoi, he himself became Chief Justice.
I was wondering when you would come to that.
And that's the most interesting part.
And when he
Mr. Salahuddin Ahmad, we became independent in 1947. We can learn from other countries by all means. But whilst we refer to Indian judgments quite generally in all the judgments, I've never seen it reciprocated in India. Have you ever come across an Indian Supreme Court judgment or any High Court judgment which has ever referred to a judgment of Pakistan?
But I think there are some very early ones, but not of late at least.
I'm just saying this perpetual fascination with what happens across the border. Why can't we just stick to our constitution, their constitution? We've seen what they've done with their constitution. I don't know how they're going to decide Article 370. Let's see the independence of the judiciary there. Let's not put that as the benchmark for best what happens in the world. Let's stick to our own thing. They are welcome to theirs. Let us be guided by our own lights. I mean, we're not looking to Islam. I mean, you know, that is brushed under the carpet. We're looking to India, we're looking to the US, and when anything Islamic comes up, the constitution starts with the word. Islam mandates the right of appeal. Even the Almighty does not condemn without having heard. And why we are not going by our traditions at all? I mean, just everything Indian, everything. They don't even reciprocate. I mean, fine, they don't need to. That's up to them. But why are we so beholden always?
I'm saying the opposite, sir, in fact. I'm saying that one should also learn from the mistakes of our neighboring jurisdictions, not just from their judgments. And that is why I was pointing out, sir, that Justice Raman Gogoi, when he became Chief Justice, the bar went to him and said that now reform the powers of the Chief Justice. He refused, and then there was a sexual harassment petition against him, and he fixed it before himself and dismissed that. So the Indian citations, I agree with your lordship, are to be taken with a pinch of salt. Now, a similar situation, sir, arose in Nepal. And I do think, sir, that when we are looking at foreign examples, perhaps relying upon US and UK jurisdictions itself might not be so apt for our socio-political economic realities. We should look at countries closer to us.
So we are taking a poll of the countries in the world.
Not at all, sir.
I mean, 200 countries do this, we must do it, or vice versa.
It is a reflection of the same problem that has arisen elsewhere.
But to your knowledge, I mean, before you move on to Nepal, in India, up to now, has Parliament then stepped into the breach?
No, sir.
No.
Thank you.
Mr. Salahuddin, whether the Constitutional Convention...
Does that mean our Parliament is more vigilant?
Yes.
You just say no, I mean, you don't expand anything further.
My Lord, I agree that our Parliament has acted because there was a vacuum.
I'm still waiting in all of this to get to
the constitutional competence. Yes, sir. I'm coming. I'll be there, sir, very shortly.
Mr. Salahuddin,
Nepal and Bangladesh and
very shortly, sir. Just two more submissions on this regard and I'll move on.
don't forget all these. Very important.
Kindly, the Constitutional Convention, does they have the status of constitution? Can they be changed in accordance to the coming situations? Or if it can be changed, who can change it? Whether convention is fixed, it cannot be changed.
My Lord, that is exactly the difficulty, as I understand it, of constitutional conventions. Because if you have a position that the Constitution says that this power belongs to A, and then the framers of the constitution amend that and they say this power no longer belongs to A. How can it be imported that the constitutional convention still continues to empower convention?
That is not a convention. That is where that situation would arise if, for example, in the 62 constitution or the interim or 73 constitution, there were words to the contrary. All that those, as I understand it, but subject to any correction from your part, those constitutions, and including the present one, has structurally gone to the position of the Government of India Act. And therefore, the case law that has come up has come in the context of the 1973 constitution. What I'm saying is that there's a background to that case law. It's not something that in 1979 was said for the first time. The conventions go back decades, if not centuries. That's what
Malo, I'm grateful for your Lordship's observation. Now, just moving on to
Mr. Salahuddin here. ये देखिए जो बुराइयां आप बता रहे हैं एनेबलिंग कंट्रीज में सब जगह हैं, क्या इन सब को रिमूव करने के लिए पार्लियामेंट ने इंटरवीन किया है या कोई दुनिया में ऐसी मसाल है कि प्रैक्टिस एंड प्रोसीजर ऑफ कोर्ट के हवाले से कोई लेजिस्लेशन भी हुई है कहीं?
My Lord, in various jurisdictions there has been.
कोई एक किसी मुल्क का बताइए जिसमें प्रैक्टिस एंड प्रोसीजर के हवाले से कोई एनेक्टमेंट आया हो?
My Lord, in various jurisdictions, for example, in the United Kingdom itself, practice and procedure of the UK Supreme Court is done by the UK by an act of Parliament.
है ना, उसमें बेंचेस की कंपोजिशन के हवाले से
Salahuddin, if I may correct you, court does not have the concept of the whole court sits, and in all the same situation of the Supreme Court sitting as a whole. There's, I think there are 9 in America. And
in the UK they do form panels, sir.
Yeah, but in other matters, but like for instance that matter of it was a full court sitting.
Yes, in both Brexits there were full courts.
So we are really concerned with those kind of 184(3) cases which have a larger impact, not in some sort of a...
Yes. Sir, I won't go through the other, I'll just point out the pages of my booklet. Page 94 details with the situation that happened in Nepal. Over there, when the Chief Justice started forming benches of his own, eventually not just the bars, but even the judges of the Supreme Court went on strike. Eventually, they agreed a system where both benches would be formed and cases be assigned through a lottery. Now, in Philippines...
Who decided this? Parliament? Or
no, sir. It was the Supreme Court. It was the Supreme Court. Now, in Philippines, sir, benches are formed.
साउथ एशिया में जहाँ कहीं ये प्रॉब्लम हुई है तो वहाँ पार्लियामेंट ने इंटरवीन नहीं किया, वहाँ अदालतों ने खुद ही रूल्स बना के रेक्टिफाई किया है उसको.
Yes, sir, but if your Lordship will appreciate, this issue has been understood here since 2006 at least.
but
it has not been addressed.
आप लोग भूख हड़ताल पे क्यों नहीं गए हैं? मैंने कहा आप लोग भूख हड़ताल पे क्यों नहीं गए हैं?
I'm too fond of my food, sir. सर मैंने फिलीपींस की मिसाल दी है, पेज 76 पे है. वहाँ सिस्टम ये है कि benches are formed through a fixed criteria, 1st, 4th, 7th, 13th in seniority.
Mr. Salahuddin, we've understood your point that there is a need for that change. The question is, who brings that change? Is it Parliament or is it the court itself?
The first
Can
option,
you just address the question?
The first option was certainly for this court could have done it through administrative rules, an amendment to the Supreme Court rules of 1980. And your Lordship will appreciate...
How the right of appeal can be conferred under the rules?
Yes, sir. Appeal is a separate issue. Magar baki, मैं practice and procedure की
Whereas the practice and procedure
has to be done separately. Now, it could have been done, have been changed by an amendment to the Supreme Court rules, but for whatever reason that was available to your Lordships was to actually do it on the judiciary, actually examine the issue of the Chief Justice's discretion and lay down guidelines and structure that discretion, etc.
Altered the convention that is set out in the earlier case law.
Malo.
That would be on the judicial side.
Yes, and in fact, there is a petition pending before this court on this issue.
On the contrary, there are various judgments of this court which reiterate the convention that has developed by way of judicial orders. Is that true?
Yes. Although my humble submission is, sir, that when the discretion of every single other individual who acts under law or the constitution, this court has held that it is subject to structuring and regulating that discretion, there cannot be an exception for the Chief Justice alone. Now, there is a petition that is pending before this court, CP number 15 of 2020, filed by the Islamabad Bar Association. I was appearing for the Bar Association in that case. This has been pending since 2020, and there is a specific prayer in this and the ground that this discretion of both Chief Justices, not just the Supreme Court, but also of the High Courts, it needs to be structured and regulated so as to improve public confidence.
Salahuddin, you have given two options
Yes.
to this court to resolve the issue.
Yes, sir.
What do you say about the right of appeal?
My Lord, as far as the right of appeal is concerned, I believe that it did require legislative intervention.
Legislation by
Parliament.
two-third majority?
Sorry, my Lord?
By two-third majority? Because
No, sir. By a simple majority.
184(3) is a constitutional provision.
Yes, sir.
And appeal is continuation of the original jurisdiction. How this legislation can create a right of appeal against a constitutional provision originally, which is part of the constitution?
Well, if your Lordship will allow, if you will give me 2 minutes, I'll wrap up this part and then come to that, because I have detailed submissions on legislative. Ji, sir. In any event, sir, it was not done on the judicial side either. It was in those circumstances that the Parliament eventually acted. Now, lastly, I'll just say this, sir, that there are 5 fundamental issues. Ji.
I think you would not disagree that the Parliament legislates. Even the Constituent Assembly legislates. But the interpretation is the exclusive domain of this court.
Absolutely. Absolutely.
The Constitution says that, the court says that, and the judgments say that, and it's a settled principle all over the world.
Yes, sir. No trouble.
So can the Constitution, can the legislature turn around and say, well, the interpretation of a constitutional provision that the Supreme Court has done is incorrect, and that by ordinary legislation we are going to correct it? Can it?
No, it cannot. But my submission is that this court, while asserting the mastery of the roster in the office of the Chief Justice, has not interpreted any specific provision of the Constitution. They have relied essentially on the Supreme Court rules, and those rules are subject to law, and I'll come to that.
So while there is legislation, is the Supreme Court now prevented from making rules on the subjects or the areas that have been legislated on?
Yes.
So that now the Supreme Court cannot make any rule on that?
It can make rules to further that legislation, and it can make rules on anything that is not specifically covered in that legislation, but the legislation has primacy.
So, from what you say, Mr. Salahuddin, a part of 191, and I would say the heart of 191 becomes redundant.
I would humbly differ with your Lordship.
Because
I read 191 differently.
Simple reading of the 191 essentially confers a power to frame rules on the Supreme Court and not on the Parliament or any other organ. So when you say the Supreme Court cannot, now that a statute is in place, proceed to exercise its powers under 191 and frame its own rules or extend its own rules or modify its own rules, You're essentially saying the 191, as far as the powers of the Supreme Court is concerned, has become redundant.
No, sir. As I said, there are areas that this court still can, but the area where a law has come into force, then it is subject to that law.
Mr. Salahuddin, ये जो आपका section 8 है इस कानून का, has that not affected an implied repeal of certain portions of the Supreme Court rules?
My lord, I don't think it does.
As it has said, notwithstanding anything to the contrary contained, so if there is any conflict, and it specifically refers to rules, the only rules that are relevant here are the Supreme Court rules.
Yes, sir. Certainly.
So if there is any conflict, then that would be a conflict with section 8, which would override. So there would be an implied repeal, I'm putting it politely. So there could then be an express repeal. Tomorrow an act of parliament could be made saying section falana, the Supreme Court rules 1980 are hereby repealed. Would that be within legislative competence?
Lord, in my opinion, it is within legislative competence, but if the effect and the substance of that law is to impair in any manner the access to justice, then it's a different issue. But legislatively, they can.
They can do that.
They can. Now, my lord,
Mr. Salahuddin, please read section 2, subsection 2. Please read that of the act, which is impugned before us.
सर अगर इजाजत दें ये वाला लेग खत्म करके फिर मैं वो प्रोविजन जी मैं पढ़ लेता हूँ सर पढ़ लेता
के साथ रिलेटेड है
जी सर मैं अभी पढ़ लेता हूँ सर Section 2, subsection 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure.
If, suppose, this enactment succeed, the again procedure has to be constituted by the committee.
Yes.
So the same procedure, which is the brainchild of 191, again has to be exercised by the committee. So the definition of Supreme Court, that Chief Justice and judges would not compromise.
My lord, as far as I understand the word...
You see, in the spirit of 191, the whole, the court is supposed to make the rules. But here only there are 3 persons to make rules. What do you say about this?
Ji sir, as I read section 2.2, when they talk about procedure, they are not talking about the procedure of the court. They are talking about the procedure of the committee, how it will hold meetings, how it will do that. So that power is not about the procedure of the court mentioned in 191. That is an internal arrangement of that committee to decide how often we will meet, whether it's every week or once a month or what, so on and so forth. So
but
that does not impact.
How do you determine that this is an internal matter for the Supreme Court to decide, as opposed to this is a matter which can be legislated on? As per your argument, once it is legislated upon, they have competence, they can legislate. The Supreme Court then cannot make any rule contrary to that. So they can make whatever, wherever they want to legislate, they go ahead and do so. But how does one then determine that this falls within the internal matters of the Supreme Court, hence no legislation, and this doesn't fall within the domain of the internal matters of the Supreme Court, hence you can have legislation? I mean, you just seem to be placing more conditions than you are in explaining how you're giving competence in a simple way. हर चीज को आप कंडीशन करते जा रहे हैं कि ये फिर ऐसे देखा जाएगा फिर ऐसे, तो that surely can't be the purpose and intention of the constitution.
Mr. Salahuddin, there are 2 things. This section 3 and section 4 is actually dictating the Supreme Court. In the matters where interpretation of constitutional provision is involved, the committee shall constitute a bench comprising of not less than 5 members. It is a dictation to the Supreme Court or to the committee. Likewise, in 3, it says it shall constitute a bench of not less than 3 members. It is dictating the Supreme Court. Then, section 8. Look at the expense of section 8. provisions of the Act shall have effect notwithstanding anything contained in any other law, rules, regulations for the timing and force or judgment of any court, including the Supreme Court. Now, where the Supreme Court has interpreted the Constitution, as I earlier said, and has set down certain rules or has interpreted the constitutional provisions, this Act, 8 Section Act, I mean, it wipes away everything and goes on to dictate the Supreme Court as to how to conduct its business. If this is not a violation of the principle of separation of powers and interference in the independence of the judiciary, what else is?
Lord, firstly, I'll submit that Section 8 is the kind of non-obstantive clause that is present in numerous statutes. Now, the thing that is to be seen, and I agree with your lordships, that if your lordships have interpreted the Constitution, Parliament cannot change that interpretation. On the other hand, there are 3 types of powers that this court generally exercises. One, you interpret the Constitution. On the other hand, if you interpret a mere statute, Parliament cannot override the judgment, but it can change the statute itself.
We have said this is a constitutional convention. Which category would you bring it? Would you bring in Molasses case and say, okay, we have changed the convention and therefore it goes?
I have humbly disagreed with the very existence of that constitutional convention. I have said that when the Parliament removed that power from the Chief Justice, there was a reasoning behind it, and there is no such constitutional convention.
Okay.
Mr. Salahuddin, one
provision. When you're dictating, the Parliament is dictating the committee. It could have dictated the Chief Justice. It is now dictating 3 judges. What prevents it from dictating the Supreme Court?
My Lord, with respect, I would not frame it in that leaden kind of terminology of dictating, but the court...
If you would just explain to this bench whether the Parliament is competent to legislate or not. If it is competent, then let us respect the Parliament and not view this as a dictation. It's a law, then competently made. So look at this in that view. But first, let us know whether the Parliament is competent to legislate or not.
So I'll now move on to the competence.
No, I just had a related observation. At the moment, we are looking at everything, nothing has happened. What may have happened, what may happen, what the pitfalls are, we are assuming those. I mean, give us this much credit that maybe whether the use dictation is used or any other word is used, may please, if the word please had preceded it, would have made a difference. The question is, this law, one way would be to let it function. And then in its functionality, you may still not be satisfied, or someone may not be satisfied and say, okay, you have not abided by the law. That question, I mean, we are assuming that we are not capable of manning this ship. The only thing is that previously there was the sole pilot. Now there are 2 co-pilots, maybe in determining things go wrong. Maybe that's a possibility. After all, for instance, when the Chief Justice leaves the country or falls ill, the acting Chief Justice comes in and he assumes the power. So why are we scared of our own shadows? I mean, the co-pilots, if they are there, why we are all assuming that we are leading to the iceberg which lies underneath? Nothing has happened so far. So we are actually, it's all conjecture and surmises we are based on. And the only real question comes down to is the competency. Well, that's the only real question as I see it, which Ijazul had asked the very first day. The focus on that. Either you can make the law, you can't make the law. Now, what may or may not happen, and whether you call it dictation or you call it a request or you call it whatever you want to call it, better way of doing business, being more inclusive, participatory, transparent. I mean, you can give it any adjective or use before that, at the end of the day, it's simply, can they make the law or not? If we even accept that this challenge lies under 184.3, just going ahead and saying, yes, okay, it lies under 184.3, just tell us that this law is constitutional, that's all.
Yes.
And whether it may not work tomorrow, and then again, people will keep challenging it. I mean, people move applications under whatever, Order 26, whatever of the rule, Order 33, where the rule prescribes something to do in a particular manner, they move an application. I could not do so, please condone this. I mean, I don't know how we're going to interpret it when it comes up. So we don't want to tie our hands down how the future will be interpreted. I will come back to, Ijazul has been asking, there's only one question, is competency of making this law.
I'll move directly to competence. Legislative competence of the Parliament may arise in at least two ways. It may arise through reference to Article 142 and the specific entries in the legislative list, or it may arise through direct authorization by some or other provision of the Constitution. This court has recognized that. I think Mr. Bandari had already 2014 Supreme Court
2014 Supreme Court
532 62.
ये दिखाइए जी. Citation 532.
Yes, sir.
2014 Supreme Court.
नाम क्या है केस का?
Province of Sindh versus NQM.
ये डिलीमिटेशन वाला केस है.
531 है.
जी सर.
डिलीमिटेशन.
जी सर, बिल्कुल. इसका relevant paragraph 62 है सर. I don't want to read this whole para. Third line from the bottom of the page, 577. The Constitution provides for competent legislature. It is not necessary to look into. And इस paragraph में फिर कई मिसालें दी गई हैं कि कहाँ constitutional provision ने authorization दी थी, कोई corresponding entry federal legislative list पे नहीं थी. अब in my concise statement in paragraph 31, I've given about a dozen examples. I'm not going to take your lordship's time right now, but para 31 mein I've given a dozen examples where Parliament is given power to legislate on subjects which are not covered by any legislative entry.
So what is the answer over here in this case?
Over here, my reliance will be 191. 191 in the cases of 2, 3, 4, 6, 7, and 175(2) in the case of Section 5.
So how do you read subject to?
Yes, I'll just come to that, but if I may first complete this.
So you're not relying on entry 55?
Entry 55 is relevant as far as 175(2) and the appellate power is concerned. I do not believe that entry 55 is relevant as far as practice and procedure are concerned.
Also not 58.
58 I will be relying upon.
You will be.
Yes, sir. Because my view of 58 is entry 58, and I was just going to come to that, is different from what has been expressed by your lordship. My view of 58 is that after the 57 previous entries which deal specifically with a particular subject matter have been dealt with, 58 is a catch-all kind of provision.
Does it confer legislative competence?
What it does is, sir, it recognizes, it does in the second part. In the first part, what it basically recognizes is that there will be things in the Constitution that directly authorize the Parliament. So wherever it does that, that is within its legislative competence. So that is the part which says, if I can just read. Matters which under the Constitution are within the legislative competence of Majlis-e-Shura, Parliament. Now this is meant to cover, as a catch-all kind of thing, those direct constitutional provisions.
And then it is followed by 59.
So
so we should read 58 totally independently and not give it a restrictive meaning as 59 would indicate.
Exactly. Exactly.
If 58 wasn't there,
yes,
then we are left with 59.
Yes.
Then you are saying you could be in trouble. The law could be in trouble.
Exactly. Exactly.
Otherwise, flesh it out.
Exactly.
Okay.
And your Lordship will also see that
surely 59 relates to the other legislative entries.
Yes, sir. 59 deals with when you are covered by a specific legislative entry, it gives ancillary powers, the penumbra around it. But 58 deals with the situations where Parliament has been directly authorized by the Constitution, outside of the list. And then there, sir, is there also the part that or relate to the Federation. And that is another broader catch-all kind of entry, which recognizes that there may be things that we have missed out in the earlier 57 entries. If by reading of the text of the Constitution, it is clear that a particular subject or a particular field would naturally vest in the Federation.
The number of judges in the Supreme Court is fixed by Act of Parliament or presidential order. The number of judges in the High Court is fixed by law.
Yes.
And or presidential order. Law over here would mean what? Would it relate to entry 58 or relates to the Federation?
In 193, the number of judges of the High Court?
Where it says law. Now, would it be covered by this latter part or relate to the Federation?
My Lord, I would, for the High Courts, as far as I know, there have been provincial legislation.
That's what the point I'm making. That it does certainly relate to the Federation because under our system, under the Constitution, our Constitution, unlike say the US Constitution, we don't have separate federal court system and state court system. One unified court system applies both federal and provincial law. So insofar as high courts are concerned, in one sense it does relate to the Federation. But as soon as you say that, you remove the provinces.
My Lord,
and if you remove the provinces, well, provinces can say, well, wait a minute. I mean, high courts surely have something to do with us. So it's not that simple. You see, that's why I'm saying, that's why I was putting it to you, but I understand you disagree that this is a negative point. You say no, it confers legislative competence. I understand your point.
My Lord, I'm grateful. Now, my submission, of course, is that Article 191 is a standalone enabling provision. Read with the first part of entry 58, it is more than enough to confer legislative competence on part of Parliament. And moreover, the Supreme Court, and I appreciate your Lordship's point about the difficulty of the High Courts, and there is, in a sense, in fact, even our provincial courts, also the CRPC, and there are numerous.
सलाउद्दीन साहब, उसमें देखिए एक और एस्पेक्ट था कि वो जो 191 का इक्विवेलेंट है फॉर द हाई कोर्ट्स, वो क्या है 201 या
जी सर,
उसमें आप देखिए एक और एस्पेक्ट था, उसमें प्रैक्टिस एंड प्रोसीजर की बात हो रही है ना, हाई कोर्ट की प्रैक्टिस एंड प्रोसीजर, लेकिन देयर इन द कंकरेंट लिस्ट देयर वर स्पेसिफिक legislative competences with regard to procedure, civil procedure, criminal procedure. So the position of the high courts were in the context of 201 is perhaps some different from the position of 191, where, as you have noted in your, I think, submissions or something, under 56 Constitution, 62 Constitution,
there was specific legislative entry for the Supreme Court, which has been taken away.
Yes, sir.
ये एक बड़ा इसमें एक एस्पेक्ट है ना इसके अंदर कि आप देखिए कि law over there for high courts was not just any equivalent, or I don't think actually there's any equivalent to 58 in the concurrent list, but it could be related to specific legislative competences.
Well,
यहाँ पे एक बड़ा फर्क है ना, आप जरा काइंडली इस पे थोड़ा एक्सपैंड करिए। इशू इतना आसान नहीं है ये, this is a complex issue which has many ramifications.
Well, Lord, the other submission that I was making is that regardless of the case of the high courts, the Supreme Court at least is undoubtedly a federal institution. It relates to the federation, and therefore the second part of entry 58 would also come into play. Now, I've already submitted that as far as I'm concerned...
Can you repeat this point? I didn't quite get it.
Sir, matters which under the Constitution are within legislative competence of Majlis-e-Shura or relate to the Federation. So, matters, as far as the Supreme Court is concerned and its practice and procedure, etc., that is obviously a matter that relates to the Federation. The Supreme Court, there might be a different view or a concurrent kind of thing as far as the High Courts are concerned, but at least as far as the Supreme Court is concerned, it is a federal institution, it relates to the Federation, therefore it is even otherwise covered by the second part of entry 58.
How will you
The
reconcile?
other issue about the High Courts and the Supreme Court, this problem which we are facing in the Supreme Court, the High Courts, to the best of my understanding and knowledge, and even when I was practicing law, this problem was not faced. The problem faced by litigants mostly was that my case is taking forever to be fixed. But this, I never came across this matter of which cases would suddenly pop up and there would be an urgent application, it would be granted or not granted, and all the other cases would stand in queue, wait for their turn to come up. So would it be correct in saying the High Courts are better run than the Supreme Court? I know you may as counsel not be able to say this, but I, as the Chief Justice, may pose this question that, I mean, in Bulusan High Court, I never had this problem. No lawyer even complained or even suggested or ever wrote or application was submitted that of this nature that, you know, my case is being, for bench-specific cases are being made. I mean, there was the criminal bench, there was the constitutional bench, there was the other benches, single judges benches, the company judge, and they would rotate after once in a while. And this issue, at least I as a Chief Justice never faced, and as a lawyer, practicing lawyer mostly in the Sindh High Court, but elsewhere as well, did not come across this problem. Is there such a problem in the High Court?
My lord, to be frank, it depends on High Court to High Court and Chief Justice to Chief Justice and the Chief Justices of this court. And that is precisely the rationale for this law, that it should not depend on Chief Justice to Chief Justice. There should be some kind of framework and structure that is.
And the only other thing which,
committee to committee.
and I would only change it, one more thing I should add. And the other reason why that problem does not exist is because there is a forum of appeal. You're not happy with a High Court appeal, HCA judgment, or an inter-court appeal judgment, or a judgment, you have a forum of appeal. So that problem does not exist. So here the problem has culminated with a number of factors. Accumulation of powers, the random exercise of power, the non-transparent manner of operating of power, the excessive use of 184(3), going into matters which are very private and individualistic or maybe not within the domain. So a combination of these factors has resulted in this act, in the making of this act, to impute some malafide to Parliament. I think that would not be fair at all, because lawyers have been in the forefront of asking for this kind of, maybe we are left with the mode and manner of who does the law. Even I haven't heard anyone from the petitioner side saying that's fundamentally wrong in this law. So all they're left with is basically, again, competency, who makes this law and who's authorized or constitutionally authorized to make this law. So the problem was created, maybe, and this is Parliament's effort to maybe resolve the problem.
Sir, agree, sir, that our grievances in respect of the high courts are somewhat less intense because we can always knock on your doors for correction. We don't have that option available here. But just to add on to your lordship's observation of it may vary from committee to committee, and yes, it may. But the thinking...
Surely the solution is, logically, give the power to the full court, which is where presumably it always lies when the court makes its own practice and procedure. Because you see, you started out with internal independence and all of that. With internal independence का तो एक ही logically एक ही हल है ना जी कि भाई अगर if the court, and I'm not saying I agree with this because with very great respect I definitely have a serious reservation with things being imputed to retired chief justices, random this, and with all due respect, sir, this is not proper. We should not impute things to those who cannot defend themselves sitting in open court. We should not do this. But anyway, let me move on. So logically the conclusion is that the matter should be placed in the hands of the full court because otherwise there is never any internal independence. But the matter doesn't even end there because full court always decides by majority. So logically, the minority is always in thrall of the majority of the full court. So then logically, the answer would be that the matter must always have unanimity. In other words, each and every one of us will have veto power over anything and everything relating to practice and procedure. The whole thing, with all due respect, in my view, then collapses like a house of cards. This is not the way these things happen. If there is a master of the roster, and I'm again asking you the question that to which, with a very great respect, Mr. Ibrahim did not give an answer. Who, if this law is validly enacted, who is the master of the roster? The creation of Parliament, whether it be a committee of 1, 2, 3, 4, 10, or Parliament. And if Parliament is the master of the roster for practice and procedure of the Supreme Court, where does that leave separation of powers? Where does that leave independence of judiciary? Kindly answer this question.
My submission
First,
is...
would you kindly finish with the competence of the Parliament? If the Parliament is competent, then the law is also competent.
So your short answer to this question and
as I've understood, your argument is that as far as the practice and procedure is concerned, that entry 58 is to be read with Article 191. And if it is a question of power and jurisdiction, then it will be covered under entry 55. Is that correct?
Yes.
But I have a problem here. The examples you set out in your para 31, none of them use the same language as Article 191. They are all enabling languages that are used in all those articles where it says by an act of Parliament, by or under an act of Parliament, as may be decided by Parliament. So they are clearly enabling. There is no doubt in any of those articles that you have listed that Parliament can make law. But here you are saying, please read subject to the Constitution and the law as being an enabling power, which is not the same and definitely does not fit into any of the examples you give. So again, the question is how to read the word subject to as an enabling power, as a means of giving competence, because the word subject to is used throughout the Constitution. Whatever you will give meaning to here, you'll give meaning to throughout the Constitution. So where is this a law-making power because it says subject to the law? How do we say that this means just an act of Parliament because it includes an act of Parliament, but but we won't look at the fact that it includes an ordinance as well, or it can include some rule-making authority which is under the Constitution? How do you address that issue?
I'll come to that. If I can just wrap up this bit and then pointed out, I made my submissions about entry 55 and 58 and 59. One alternate argument is also, and although I hesitate to make it because I'm on the other end of those cases, but this court has held in two judgments, Fiakat Hussain versus Federation of Pakistan, which is PLE 2012, Supreme Court 224, at paragraphs 33 and 35. And then in the Government of Sindh versus Nadeem Rizvi, that is commonly known as the JPMC case, which is 2020 SCMR, page 1, at paragraph 27. And in those judgments, your lordships have held that Parliament has independent legislative authority to frame legislation in any matter regarding enforcement of fundamental rights, and that is without prejudice, without irrespective of any legislative entry. Now, I filed a review against the latter judgment, so I'm hesitant to get a full court finding on that issue. But if that is indeed the correct law.
Surely that case law which, well, the matter is under review, so I myself will not say what I think on that point. But that case law surely does not allow or does not contemplate a violation of some other constitutional provision which is lying at the heart of the Constitution, for example, separation of powers or independence of judiciary. Surely you are not arguing that it goes that far.
Because right now, no, if it violates independence of judiciary, so then sir, because that is now the second leg I'm coming to.
Separation of powers.
Bilkul, equally. What I'm saying is that you might have all the legislative competence in the world. You might have 20 legislative entries in your favor. But if the law that you come up with violates separation of powers and independence of judiciary, then equally it is to be struck down. But the difference between that and competency is that in competency, you don't have to look at the merits of the legislation. When you are gauging it on the basis of independence of judiciary, I would submit, and I'll come to your lordship, that merely exercising that power violates that independence of judiciary. I'll address that as well.
But we are not even clear कि clear competence है कि नहीं, क्योंकि वो subject to है, and you still have to address that question.
मैं ये अर्ज कर रहा था कि अगर if I'm able to convince your lordships that the legislation by Parliament in this case is meant to promote the access of justice under Article 10A, in that case that would be an independent source of legislative competence. The issue of what is to be primary, what is to be afforded primacy, whether the law should rank over the rules or the rules should rank over the law, that I'll address now, sir.
Your answer to the question is that subject to the Constitution and the law is enabling because?
It is enabling because it is a standalone enabling. In my reading of it is, it recognizes 191, recognizes and presupposes the existence of legislative capacity. And
but you would have to go back and see what that legislative capacity is. You'd have to go back and see what legislation we're talking about. It is not necessarily only legislation related to practice and procedure. It can be any other kind of legislation, say on the law of limitation, which says that the Supreme Court can make its rules, but it can't make rules which will then ultimately affect the law of limitation because that is governed by a law. So we go back to look for competence. So again, I take it that there's no clear answer here.
My submission would be that limitation itself is a matter of procedure. It gives rise to vested rights, of course, but it is fundamentally a matter of procedure.
It can be read that here to your right side. Right?
Sorry, sir.
You need to have lights here.
So it means that the rules must be in accordance with every law.
Yes.
It must not be specific to some law. It must be in accordance with Constitution and every law of the country. You should not derogate.
Yes.
इस तरह भी पढ़ सकते हैं.
Sir, बिल्कुल.
Mr. Salahuddin Ahmed, here we have specific entries. According to you, 58 is attracted. According to some others, 55 is attracted. But in America, there was no specific entry, and they read into the Commerce Clause. I don't know if you know, know the judgment of the Commerce Clause, and gave it a very extremely wide meaning, which probably neither the Constitution makers, though they said that was the intention, but it wasn't reflected in the words. And there is a judgment of this court which has used that argument in, I don't know if you were representing in the Sindh Revenue Board case. I think that was a case on that.
No,
on
sir.
the Commerce, it was given a very wide meaning because Congress's power was upheld.
Yes, sir. And almost everything was then fitted into the Commerce Clause. Yes,
Yeah, exactly. So you've read that judgment.
Yes, sir. Yes. Okay. Sir, I wanted to address now, with your Lordship's permission, the issue of whether Parliament, that if Parliament can make laws relating to the procedure of this court, then whether those laws are to be subservient to the rules of this court. My humble submission is that making the law of Parliament subject to the rules of this court would amount to distorting the plain meaning of the constitutional provisions. Because no matter how liberal or purposive the interpretation, subject to the Constitution and law cannot possibly be read to mean that notwithstanding the law, the Supreme Court shall make rules. The constitutional provision clearly establishes a hierarchy. The Constitution, the law, and then the rule-making power of this court.
आपने जब फरमाया कि law can repeal the Supreme Court rules, that is, if I understand correctly, your position, and do it expressly.
Yes, it can.
Then that, perhaps, that is your answer then?
Yes, yes, yes. Now, there is a contrast that I would like to draw, sir. If your Lordship sees...
Would you be taking a lot of time, or how long would you?
Sir, about 20 more minutes, sir.
20 more minutes.
I'm so
we
sorry.
can either take a break now, or we can take it out. Let me ask my colleagues then, whether they want to take a break now, or now or later?
Now, maybe.
Now?
Hello.
So, we take a break and 20 minutes, 4:20.
Hello.
420 doesn't sound nice.
4:20.
421, sir.
4:22. Sorry, sudden. ठीक है, तो आप लोग कितने रह गए अभी? पाकिस्तान बार काउंसिल. अच्छा. There was a time when people would say, I adopt the arguments, but it's not happening in this matter.
That was before the live telecast, sir.
If one agrees
Those
with the
precedents are no longer applicable.
I don't see any adopters here.
So shall we pull the plug? ठीक है? अच्छा, चले.